Well, welcome everybody. Thank you for getting so quiet in a uniform way so quickly. That was wonderful. My name is Professor Collis. I'm a law professor here and the faculty director of the Bech-Loughlin First Amendment Center. I just want to briefly welcome you on behalf of the First Amendment Center and then get out of the way. I will tell you, those of us in the First Amendment space who take this seriously, and by this I mean exploring and expanding knowledge of the First Amendment, have one common, very serious problem we are regularly trying to solve. And in the law and religion context, we refer to it as the Puritan mistake. And we often say about the Puritans that they came to these shores for religious freedom, which is true, they did, but they were interested in religious freedom only for themselves. As far as they were concerned, everybody else could just get out of Massachusetts, and they literally passed laws to that effect. And we see that for all First Amendment freedoms, including the freedom of speech, a tendency to want to protect speech we like and oppress speakers with whom we disagree. And I can think of no laws right now percolating around the country that might reflect that tendency by both the political right and the political left more than bans on drag shows. So I'm thankful for our one of our research assistants in the First Amendment Center, Sydney Jean Gottfried, who put this event together, partnering with Outlaws. And I look forward to what I hope will be an important and serious discussion about drag bans specifically, but also free speech principles more generally. And with that, I'm going to turn it over to Sydney Jean to introduce our panel today. So, Sydney Jean.
Hey guys, I'm Sydney Jean. I have the good fortune of being on the board of Outlaw and a research assistant at the First Amendment Center. So it's very exciting to get to combine those two interests and communities today. I'm going to introduce our panelists and then just set the agenda for the hour. So on my left, we have Professor Caroline Corbin from the University of Miami School of Law. She teaches courses on constitutional law, feminism and the First Amendment, and advanced topics in reproductive rights. Her scholarship focuses on the First Amendment speech and religion clauses, particularly their intersection with equality issues. To her left, we have Chloe Kempf, who's an attorney and Gallagly Family Foundation Fellow at the ACLU of Texas. Her work seeks to defend and expand the rights of LGBTQIA Texans. As a member of the ACLU of Texas's free speech team, she also engages in litigation and advocacy to protect the freedom of expression for all Texans. And very importantly, Chloe received her JD right here at Texas Law in 2021. And to Chloe's left, we have Brigitte Bandit, an Austin-based activist and drag performer who has been testifying against anti-drag bills in Texas since 2022. In August 2023, the ACLU of Texas and Baker Botts filed suit on behalf of Bandit and other plaintiffs to challenge the constitutionality of the Texas drag ban, SB 12. Last September, a federal judge in the Southern District of Texas ruled the ban was unconstitutional and issued a permanent injunction blocking the legislation from becoming law. So we're going to start out with Professor Corbin laying the legal landscape on efforts to ban drag, where those efforts fall in the broader free speech context and implications for the queer community. Then we'll hear from Chloe and Brigitte about their experience actually litigating the case. So we'll get started with you. Thank you.
Okay, so I have PowerPoints, so that's why I'm standing here. Okay, so I am so happy to be here. This is a very fun panel. And I'm here, obviously, to talk about the First Amendment and Texas's ban on drag. And I just want to show, whoops, why is this not working now? What happened here? Let's see. Sorry, it was working when we started. So, let's see if it works. There we go. Sorry about that. Okay, so Texas didn't ban drag directly, but it banned sexually oriented performances in the presence of minors, where sexually oriented performance is defined as a performance that features someone engaging in sexual conduct, and sexual conduct is defined as the exhibition of sexual gesticulations using accessories or prosthetics that exaggerate male or female sex characteristics. Now, surprisingly, it was neither Florida nor Texas who pioneered the drag ban, but Tennessee. Naturally, Texas and Florida followed suit, as have several more states, including Montana, Alabama, Arkansas, Iowa and a lot of other states are also hoping to pass their own version. That's the bad news. The good news is that courts that have been considering these bans have found them to be unconstitutional. So, as your lunchtime constitutional professor, I will primarily explain why drag bans like Texas's violate the free speech clause. Second, I'll talk about how these bans are part of a larger trend of anti-LGBT legislation. And finally, how the targeting of the LGBT community is itself evidence of growing Christian nationalism in the United States. So I start with speech and I end with religion. Okay, so some free speech basics. So one of the most paradigmatic violations of the free speech clause is government censoring speech it does not like. Translating that into doctrine, since you're law students, that means that laws that regulate the content and especially the viewpoint of speech are presumptively unconstitutional. They're not automatically unconstitutional, but they trigger strict scrutiny and they're not likely to pass. And drag bans are a good example. Right? The law on its face is content-based, since it singles out sexually oriented performances and expression. It's also viewpoint-based, as it targets the idea that drag is fun and family-friendly. And in fact, an earlier version directly mentioned drag performances, but they try to hide the fact by changing the language to look a little more neutral. And indeed, the government tried to argue that this law was not regulating expression and that it was certainly not trying to censor any topic or viewpoint in particular, but the court was having none of it. So, the law regulates the content of speech, triggers strict scrutiny. The general rule of strict scrutiny is that the government interest has to be compelling and the tailoring of the law has to be narrow. That is, you can't accomplish the government's goal by some other means that did not infringe on the right so much. And if you apply here, the government's compelling interest is protection of children. And you can't quibble with that, right? Protecting kids is a compelling government interest. But the law is not narrowly tailored, right? The claim about jeopardizing children is really just a pretext for the obvious animus the lawmakers bear towards drag performers. So, for example, there are lots of different ways this law could have been written, even setting aside the animus point. There's lots of different things this law could have done, like make distinction based on the children's age, or allow an affirmative defense that parents can make decisions about whether their children are allowed to see it, but it doesn't. Right? So this law, which is content-based, fails strict scrutiny, violates the free speech clause. But wait, there's more. Because it also is a vague law. And vague laws are those where the language is unclear or ambiguous, so much so that a reasonable person is really not quite sure what is allowed and not allowed. And this alone is a due process violation because due process requires that you have adequate notice of what you are and are not allowed to do. But vagueness is also a free speech problem when vague laws regulate expression because vague laws tend to chill speech. That is, when people aren't sure what speech is going to get them into trouble or not, they err on the side of caution and censor themselves. And so, again, vague laws that regulate speech chill speech, and that is problematic under the free speech clause. And there's a lot that is vague about this law, so just to, right, if you again look at the law here, the district court decision focused a lot on appealing to prurient interest and how it wasn't quite clear what that means. I'm personally more baffled by the requirement of an exhibition of sexual gesticulations using accessories or prosthetics that exaggerate male or female sexual terror. I don't know what that means. Like wigs? Like big fake eyelashes? That's pretty widespread. Push-up bras? I don't know. I don't know what's in, I don't know what's out. Right? The law is vague. So, oops, let's go back to, all right, so unfortunately, right, there's been an explosion of recent laws attacking LGBT community, like especially in Texas. Apparently Texas leads the nation in proposing anti-LGBTQ laws with over 140 bills proposed just in 2023. And so some of them are like laws prohibiting transgender medical care for minors. The AG even declared that this medical therapy amounted to child abuse. There's laws restricting what teams transgender athletes can compete on. There's been the abolishment of diversity, equity, and inclusion programs at public universities. There's more on the horizon, like the Don't Say Gay law, which is modeled on Florida's, which prohibits instruction on sexual orientation and gender identity. In other words, this is not a one-off, but part of a concerted attack. And I hope it's obvious that these laws that target based on sexual orientation and gender identity are discriminatory, hostile, create an unwelcome, if not traumatizing experience for those who may already be marginalized. But you asked me to talk about the First Amendment rather than equal protection. So my last point is that these laws themselves, these anti-LGBT laws themselves are part of a broader agenda. And I think Christian nationalism captures this. So what is Christian nationalism? So Christian nationalism is the belief that the United States has always been, and should always be Christian in its values, its symbols, and its laws. And in fact, Christian nationalist organizations have been helping to draft some of these model drag bans. Christian nationalism is the opposite of separation of church and state because it envisions a complete overlap, meaning a Christian state. And a Christian state means imposing their conservative Christian worldview onto everyone with their Christian-based laws. So not only do you have all these anti-LGBTQ laws, but you also have attempts to return Christianity into the public schools, and you have all the attacks on reproductive rights as well. Right? And this conservative Christian worldview has very specific views about men and women and sexuality and conformity to traditional sex roles. Right? Deviations are not tolerable. So the hostility to abortion is partly driven by that lingering separate spheres ideology that women should be mothers, they should want to be mothers, they should only have sex in order to be mothers, right? And so there really should be no abortion. And the hostility to the LGBT community is that queer people subvert traditional, immutable, God-given sex hierarchies and roles. Right? It's harder to insist on the immutability of sex roles of men inherently are like this and women are inherently like this if there are queer people who don't fit nicely into either category. And especially with drag, how they highlight how gender is not inherent but often performed, and whose very existence really destabilizes the whole regime. And so that's why you get laws like the drag bans that try to erase them and render you all invisible. Right? But not today, Christian nationalism, right? Because the drag bans violate the First Amendment. Thank you.
Thanks so much, Professor Corbin. Chloe, we'd love to hand it to you to hear about the experience of actually challenging SB 12, what it was like working with some of the other plaintiffs on the case, and also, if you have time, your experience on the free expression team at the Texas ACLU.
Yeah, thank you so much, and thanks, Professor Corbin. We were tracking SB 12, the drag ban law, from its introduction into the legislature. Even as Professor Corbin said, it doesn't say the word drag, but it was billed by lawmakers from day one as a drag ban. It was made very clear what the law was meant to target. You saw some of the language in the law as well that speaks to typical aspects of drag performance. And then also folks like Brigitte, who were really brave and going up to the Capitol to testify over and over again, kept the issue on our radar. And it was one of a suite of bills that we were watching that, just as Professor Corbin was describing so beautifully, there's this really strong overlap between bills in the legislature that restrict LGBTQ equality while also infringing on First Amendment rights, and this kind of broader effort to drive queer people out of public life and out of civic society. And so SB 12 was a big priority for us. When it passed, but before it went into effect, we had a few months, and that's when we filed the lawsuit, a pre-enforcement challenge, facial challenge of the law. We represented Brigitte and also a drag telegram delivery company called Extragrams, two pride organizations, the Woodlands Pride and Abilene Pride, and a San Antonio-based drag entertainment service called 360 Queen Entertainment. And so there was diversity from plaintiffs across the state and also in terms of where they fit into the drag performance industry. And when we filed our lawsuit, we asked for preliminary injunctive relief, but it was within the judge's power to convert our request for a preliminary injunction to a full trial on the merits. And he did so. We filed in Houston in the Southern District of Texas. So we had about 2 weeks to prepare for a full trial on the merits, which was it was enough time, but it was quick. And it probably felt quick for you too. Mm-hmm. And so, yeah, we had to prepare to put as many facts on the record as we could to prove up our full case at trial. And obviously there were a lot of factors that we needed to establish through the testimony of our plaintiffs. But a major one was, the chilling effect of this law, its vagueness that Professor Corbin was talking about, and the way that our plaintiffs, their performances are what's called arguably prescribed by the statute, how they might be swept in by this law's vague and broad sweep. And so a lot of the testimony focused on that. And so yes, we went to trial 2 weeks later. It was a 2-day trial. Because the law is quite complicated, there were many defendants involved. The law has both civil and criminal penalties. And so we had to sue, the many defendants that would have enforcement power under SB 12, from municipalities who were charged with making regulations against drag and other sexually oriented performances, the Texas Attorney General, and also the district attorneys of the counties where our plaintiffs lived. And yes, the judge granted a temporary restraining order right after trial as he considered his final ruling on the merits, because the law was going to go into effect in 2 days. And then eventually he ruled that the law was unconstitutional for 5 distinct independent reasons: content discrimination, viewpoint discrimination, vagueness, overbreadth, and as an unconstitutional prior restraint on speech, and permanently blocked the law. Yay! And of course, permanent as the district court can get. We're now on appeal at the Fifth Circuit, and our briefing is due in mid-April. So we're working on that in earnest right now. And then I can briefly talk about our other work on the free speech team. We focus a lot other than our drag ban case, on free speech issues in the K through 12 and higher education context. I'm sure you are aware that there is a push to ban books at essentially every level of government in Texas, from school boards to municipalities, all the way up to the state who recently passed HB 900, a book banning bill. So we filed an amicus brief in the HB 900 case. And we've also taken up a relatively new strategy of filing Title IX complaints against school districts that ban books on the basis of characters or themes that are LGBTQ. The Biden administration's Department of Education has said that that is potentially a cognizable Title IX complaint. So we have one active investigation and a few other complaints that we filed against school districts that have banned, for example, one school district banned all books that mention the concept of gender fluidity. And we also are interested in dress code work. This is another cross-cutting issue between multiple issue areas at the ACLU of Texas, but many times dress code restrictions, like on religious garb, on hairstyles, on particular messages on clothes, can also infringe on students' First Amendment rights. And so we have a few cases in that context as well. But happy to talk about any more of our work in the Q&A portion.
Great, thank you. And then Brigitte, we'd love to hear about your experience testifying before the Texas legislature and as a plaintiff on the suit, maybe your decision to join the suit, and how a threatened drag ban impacts your life and your livelihood.
Sure. Okay. Hi. So the first time I testified against SB 12, it had defined drag differently. It started with the definition of drag as a man dressed as a woman or a woman dressed as a man, which is so boring. What a boring way to define what drag is. And because drag is, you know, we're all born naked and the rest is drag. Y'all are all in your student drag right now. Yes, Chloe's in her lawyer drag. Yes. But I'm somebody who's born female and does drag as a feminine presenting person, as Brigitte Bandit. Has anybody seen me before? Ah, okay. Okay, cool. The rest of y'all got to come to a show sometime, okay? So I went up there in full drag, and that went viral because people were like, "Oh my God, it's an actual woman!" Blah blah blah, whatever language they like to use, right? But then they changed it to attack my big Dolly Parton. And so I had to go back up there again because Dolly is my main moneymaker, all right? And God did not bless me with Dolly's silhouette, all right? I had to get some help from dramazon.com for that one. But I think it's so silly because, you know, Dolly Parton exists with the way that she looks around children, and nobody seems to bat an eye, right? But if I were to dress like Dolly Parton, even though I'm also somebody who's born female, but I look like this version of femininity that they do not agree with, or that they think that I'm a man whenever I'm in drag, all of a sudden it's inappropriate, right? So silly. But yeah, so then I testified the second time. The second time I testified, I was escorted out by the police. It was only because I went 15 seconds over my time frame. Okay, and I don't think they liked what I was saying either. And I had waited 13 hours to speak, and I was escorted out by the police. But that's online. Y'all should go look at that. But I was very grateful to be a part of the lawsuit with the ACLU. It was so nice to finally work with like people in this process that actually like gave a you know, who actually cared and listened to our concerns or whatnot. But it was scary going to testify in court again, and that the hands of, or the fate of like my drag community was in the hands of an 84-year-old judge that was appointed by Ronald Reagan, right? Mm-hmm. Which is, I'm like, gosh, that's really how our system works. But he was cool. He was very smart. He was very sharp. He was very interested in my He said, those are free speech. And Chloe did an excellent job of Yeah, I mean, it's fun to talk about now, right? But it is kind of frustrating that we're even here.
And we did have to get into that because part of the law that we didn't talk about says no lewd exhibitions of female or male genitalia or accessories or prosthetics that exaggerate male or female sexual characteristics. So to prove up our case, we had to get into the weeds of what you wore.
Mm-hmm. Yeah, well, we had to talk about, because it's like if any part of the buttocks is out, or you're wearing accessory or prosthetics that accentuate sexual characteristics. I'm like, is this little kitten heel is that sexual to you? What if you're into this, that's up to you. That's on to you. Yeah, and with drag, it's very hard because a lot of drag queens, they put padding on. So they basically put like couch cushioning on their hips to give them pads, and then they put nude tights over the cushions to make it, y'all have seen drag queens, right? They're, most of the hips are fake, okay? And, but it looks like nude, so is that gonna be considered buttocks? Like what they're trying to define drag in this way that it's like it encapsulates, I don't know what word.
Encapsulates. Yeah.
Encapsulates so much more than that, right? And then it's also very confusing. It's also like some bars will let me have my out and some bars won't, right? Because there's also this idea of what is nudity and having your nipples exposed as a female person or like somebody with breasts, right? Like is illegal. So that was another thing that we talked about. Oh yeah, and then also we had a picture of me swinging around a because one of them was any kind of like, what was it like?
A sexual device, like a stimulation device.
Yeah.
No displays of that. Yeah.
Yeah, and so the judge got to see a picture of me dressed as a little mermaid with my, because look at this stuff, isn't it neat? Yeah, so it was really interesting, and then I ended up on the stand overnight.
Yes.
So then I couldn't even talk with them after I got off the stand because they were like, "We're not allowed to talk to you," and I was like, "Well, great."
Yes, between direct and cross, we took a break for the day.
Mm-hmm. And then they cross-examined me, and I was nervous because I was like, "Oh, the state attorneys have all night to like prepare what they are going to question me with," and they did not spend a lot of time with me. Yeah, I was really nervous about that though.
Brigitte did amazing, and something else that came up as a topic in the lawsuit, which surprised me, was a few of the defendants said we don't, drag might not even be expression under the First Amendment. It's not conveying a message, and so we had our plaintiffs, and especially Brigitte, testify beautifully about what messages they were expressing through drag. So I'd love for you to talk about that if you want.
Oh, yeah, I think it's funny that they say that drag is not expressive when most of them would call me a groomer or a pedophile just because I have a wig and eyelashes on. It's like you're making a judgment about who I am, even if it's not real, just because of your own perception and the way that I'm dressed, right? But yeah, I do use drag a lot to express a lot of things, if not just to spread joy and freedom and excitement. People love drag. I think over the whenever the COVID lockdowns and stuff, I worked with Extragrams. That service that we talked about was one of the other plaintiffs, to bring drag all over Austin. I was performing in front of people's front yards all over Austin. And can you imagine you're stuck in the house and you see a drag queen on the street in your neighbor's yard, okay? The whole street would come out and celebrate together in this socially distanced, fun way. And now it's really hard to even walk on the street as a drag queen. But I do use a lot of signs in my drag performances. One time I did a drag queen story time to the tune of Harper Valley PTA, and I kind of just went through the actual problems that kids in Texas are facing. The second time I testified was right after the shooting in Allen, where some kids died at the mall. And so, and they had just let one of the bills die that would have helped restrict the access to guns for that. but they were targeting drag queens instead. So I wore a gown that had the Texas flag up top, and underneath it, it had all the names of the kids that died in Uvalde and the kids that died in Allen. And then I also used the names of the anti-LGBTQIA+ hate groups that have been targeting drag performers, which was called Defend Our Kids and Protect Texas Kids. So I put Protect Texas Kids, Defend Our Kids from gun violence, restrict guns, not drag. And so I would say that's pretty expressive, you know? It's a very powerful piece. That dress actually is gonna go in a museum. I think drag just is inherently expressive. When they said that, I was just so gapped.
Talk about how it's, I love when you talk about how it's inherently expressive.
I think drag is such a beautiful way to explore yourself in your most authentic way and express that to others, right? Because you have no limits. You have a freedom to express yourself however you want without societal restrictions or how you're told you're supposed to dress or look or be. I think everybody should do drag at some point in your life and just have fun with the way that you want to present yourself and express yourself outside of, oh, you know, you're a woman, so you're supposed to have long hair and makeup and whatever, you know, or you're a man, so you need to have short hair and wear blue or whatever, you know. Like, it's all of this idea of like gender is socially constructed, right? You can just kind of exit out of that and be like, well, who am I outside of these ideas of what the gender binary is and what it looks like? And then you learn a lot about yourself. And whenever you know yourself that well, you're able to express that to other people and form very authentic relationships. And it's very powerful, but it's very scary to the people who want to keep you in a box, you know? Yeah.
Thank you for sharing all of that. Thank you all three. We're going to open it up to audience questions for the remainder of the time before students head to class in 15 minutes-ish. So if anybody has a question, go ahead and raise your hand and Ryan will bring you a microphone. We've got Becca.
So I was a teacher in Florida and I quit government because of the speech laws that y'all were talking about. And I just wondered if you could say a little bit more about how the government speech aspect of teacher speech versus books changes some of these free speech concerns, especially when they intersect with the interests of protecting children.
I just wrote a paper about that. So, unfortunately, and I don't want to get too into the weeds, but it's a little harder to challenge restriction on public school teachers' speech because of something that you mentioned, which is the government speech doctrine. So speech is generally categorized as private speech or government speech. And the assumption is that the free speech clause protects private speech from the government. It doesn't protect government speech. So once speech is categorized as government speech, it doesn't get any free speech protection. And so what has happened is that the free speech doctrine has developed in a way such as that teachers' instruction in the classroom is considered government speech. So for those who really want to know, the legal test is if you're a government employee and your speech is pursuant to official duties, if it's the speech that the government has paid you to do and you're discharging your paid government responsibilities, then it's considered the government's own speech and therefore not protected by the free speech clause. So I think that was not always the case, but this government speech doctrine, this idea that government speech has no free speech protection, it's new and it's expanding, and unfortunately it's expanded in ways that are distressing, such as sort of precluding teachers, public school teachers, from challenging restrictions on their instruction in the classroom. So I'll stop there. I mean, I could talk for an hour about that, but I think that'll suffice.
Joe?
Here, oh,
Professor, I noticed you, oh wow, this is very loud. I noticed you mentioned that sort of the guise that these lawmakers are passing this law under is under the interest of protecting children, and I think that's kind of consistent across like a lot of anti-LGBT legislation. I guess I'm curious, and this is maybe more of a political science question, but like, is that convincing to people? I mean, presumably they're doing that because they think that that's like the best light in which to present these policies. But do you have any idea or data about whether or not like the public at large is, kind of like buys that or not?
Yeah, I'm so a con law professor and not a political scientist. I think that's a fair question, and I don't know the answer to that. But I certainly believe that in their own minds, they think their children are at risk because they really believe in this sexual binary, and that part of Christian nationalism is this idea that we have a special relationship with God and we're looked favorably upon God, but part of that deal is that we live according to God's mandates. And their understanding of God's mandates is to have a very clear sexual binary, sexual hierarchy. And for the reasons I mentioned, a lot of like drag performance, it destabilizes that, it upsets that. And so they think it's a real threat to God's favor, and certainly a threat to very deeply held religious beliefs. Not ones I agree with, but.
Like, can I say something too? I think it's interesting to me that we see these laws in, or proposed laws in multiple states. Some of them only target drag queens, but they don't target drag kings, right? Why do you think they are only targeting drag queens? And it's because the only reason that these people can understand others wanting to dress femininely is to be sexual because of the way they sexualize women. So I think that it's really important to understand these laws are not only based in transphobia, but also misogyny and upholding the gender binary and wanting people to exist the way that they're supposed to be. Also, a lot of these hate groups like Protect Texas Kids and Defend Our Kids, they'll secretly go to the drag shows, record content that they can purposely manipulate to circulate online to make it seem like inappropriate things are happening in front of children. For example, we had somebody come to a drag show where there was only one kid in the show. He purposely sat so that the kid would be in the background of the video. And then whenever the queen dropped into the splits, wearing full tights and everything, like nothing like you wouldn't see at a cheerleader show or whatever, they put a big black box on her crotch to make it seem like something was hanging out or it was inappropriate or whatnot. So they purposely manipulate images and information to push this rhetoric. I do believe that some of them really do believe it, but a lot of them are very manipulative with the way that they push their agenda and information online. And they've even taken a picture from an outdoor daytime story hour I hosted and edited the background into a dark nightclub. And so they do purposely manipulate these images and information. So that's also something to keep in mind when you're looking into these things.
Thank you.
I have a question for Professor Corbin. Thanks for coming. I'm glad the First Amendment Center could host you. You talk about a lot of this being driven by white Christian nationalists, which I think there's no question they exist and they are real, and that they would like to see the world kind of conformed in their image the way you described it. But I also think their very existence allows you to rely on that as a little bit of a straw man, because I think there's a whole lot of other people who support some of these laws who aren't Christian nationalists, who have other concerns and more sophisticated arguments and concerns that they're worried about. So this kind of actually dovetails off the question that was just asked. I'm wondering if you can articulate a little bit, or maybe even Chloe, in some of the litigation you've had, what are the more sophisticated arguments? It's easy to throw up the white Christian nationalists and just say, well, we don't want that. And I think probably everyone in this room and most reasonable people would agree with it. But there's more sophisticated arguments happening, and there's more people supporting these laws who are not driven by a white Christian nationalism. What are the other more sophisticated arguments that are coming up in these cases, behind these bills that are being litigated and talked about? Do you have any sense of that at all?
I don't sense any sophisticated arguments that justify these targeted attacks on the LGBT community. I mean, you know, I think it really is a particular view about appropriate sex roles for men and women. You don't necessarily have to ground that in white Christian nationalism if you don't want. You could just ground it in good old sexism, as you said. It's really this idea that, you know, this is how the world should be, and this is not only how we want to live our lives, but we want everyone to live their lives in accordance as well. Mm-hmm. And therefore because, I mean, the idea that this is dangerous for kids is ludicrous. I mean, let me say, I think there are some sexual performances that are not appropriate for children, but I'm pretty sure there are already laws on the books that say, you know, your kids can't go to a, you know, live porn show, right? But to have a law that says you can't have a man dressed up in glitter and sparkle, right, and read them a story is not motivated by a sophisticated argument. Now, if you're going to ask me about the free speech arguments, sure, we can talk about how they try and argue that this is not really expressive, right? Like baking cakes apparently are expressive, but a dance performance, a live performance is not expressive, or you can argue, well, it's content neutral regulation of conduct, so it only triggers intermediate scrutiny, but then you have to believe that there are actual legitimate government interests motivating these laws and not this terror of people who don't conform. So yeah, I mean, there's lots of sophisticated legal arguments you can make about these, but I don't think there are sophisticated legal justifications.
Amen. You can come to court with us next time.
Celine.
Hi. Okay, hi. Thank you all for doing this. Chloe mentioned the appeal is coming up.
Yes.
I was just wondering how y'all are feeling about that and if you're worried at all about what might happen.
No, I mean, we're feeling as good as you can about an appeal. Obviously, I wish I could talk more about it, but since it's not filed yet, like, to us, from the beginning, it was an extremely clear-cut, unconstitutional law on its face. We didn't need to wait to see how it was going to be applied. It was written in such a vague way, such an overly broad way, such a targeted, specific way about certain content that we've been confident from the beginning.
Yeah, so I have a question for Brigitte specifically, and I apologize if this is more of a philosophical question, but I'm just wondering if, like, how much of drag do you see as a performance versus an identity? Because, like, if you're just talking about a performance, drag is something that could be done by someone who's cis and straight and just wants to look pretty, versus something that a lot of queer and gay individuals use as a form of social connection, and a lot of trans people use as awakening to find their gender identity. So I'm wondering, is like, how much of drag do you see as intrinsic to being queer versus, oh, I'm just putting on a performance?
Yeah, that's a good question. I think that, yeah, drag can exist in multiple ways, right? Where you have people like Mrs. Doubtfire, where it's like a cis straight man, but he's in drag. You would say that's in drag, right? And then you also have people who, drag is, it's not only for queer people, but it's heavily connected with the queer community, right? And especially queer people who want to exist and explore ourselves outside of these societal limitations, expectations, or whatnot. And so people will find their identities through doing drag. You know, there's a lot, that's why you see on RuPaul's Drag Race, if y'all watch that, a lot of the queens will end up coming out as trans because through putting on this identity and taking it off or exploring themselves through this performance or art form, they find themselves and discover themselves, right? So I work with a lot of different kinds of performers and a lot of trans performers, and some trans performers are like, oh, I'm an entertainer, I don't want to be called a drag queen, I'm simply an entertainer, and so I think everybody can define it for themselves as to who they are and what they do with it and how they use drag for themselves. Everybody does drag for different reasons. It doesn't all have to be the same reason, and that's why we like to have discussions and to talk about how we got to why we're doing it, because obviously the reason why I do drag is going to be different than why Mrs. Doubtfire is doing drag, or any other queen on a Friday night at OCH. Yeah.
I read this really. Can I just? I read this really. One of the funniest trends I've noticed is there seem to be a lot of sponsors of these bands who themselves have done drag when they were in high school. And so I think that, there's different, as you said, there are very different kinds of drag. And I think when it's like often the powerful straight white men doing it, doing the exaggerating femininity, they're sort of mocking it, sort of saying there's something inherently ridiculous about being female. Whereas I don't think that's the position of drag queens doing it. I think it's celebrating that, and joyfully embracing it, or sometimes just displaying, as I mentioned before, how gender is something you can put on, take off, play with, and is not inherent and sort of dictated by God.
I think it's like reclaiming femininity outside of the patriarchy. It's like, it's so wonderful to be to put on so much femininity and go into a space that is not predominantly cis white straight men. It's very freeing to explore yourself in those spaces and get out of these like patriarchal expectations of these people in power, right?
And then I think we'll just do one last question from Rachel, if you want to go ahead.
Yeah, thank you so much for coming. You mentioned at the beginning that, you do drag just because it brings joy to a lot of people in one way. And I know, I have enjoyed drag, and it has helped me get through finals, courses. And I just wanted to ask if you had any, recommendations or suggestions for, us who are going to be in the legal community, or just as people who maybe don't do drag but like it, that could do to give back since we, get so much joy out of it.
Oh, well, that's it. Just come bring me $1 at the shows, okay? I think right now it's really important to have conversations with your friends and family and about these kind of attacks and rhetoric on our community. Don't let the first time they're exposed to drag be one of these videos that is doctored online. Have conversations with your friends, with your family, with your community, with your other students or whatnot, and challenge people who may not understand it yet. We talked about, you mentioned earlier about the drag, some shows are inappropriate, right? And I think some people have this idea of oh, drag only exists in the gay bars at night and it's always hypersexual, blah, blah, blah. I'm like, well, there's a reason why drag exists in the gay bars at night, because we've always been pushed out of society, right? But drag is simply a form of art, to quote myself on my thing. And any form of art, it can be modified for different kinds of people, right? So it exists the same kind of as a movie spectrum, you have your rated G movie, me reading a book at story time, and then you have your rated R with me swinging the around, So I think it's important for people to understand the spectrum of drag. So if you can have those conversations with people, show them what drag is, and also come to our shows and continue to support us, because of this rhetoric, we have seen a decline in the people who come to the shows and stuff. So I think the biggest thing you can do is just have conversations with people. Mm-hmm. And come give me $1.
Thank you all so much for being here, and thank you to Outlaw and the First Amendment Center for co-sponsoring this event to talk about a really important First Amendment issue right here in Texas. So thanks.
Thank you all.